Okay, good afternoon. Okay, let us discuss yung Batas Pambansa bilang 22 or otherwise known as the Bouncing Check Law. Okay, bali part pa rin siya ng RFDT 2905, okay, doon sa Negotiable Instrument Law kasi ang kasama doon sa materials nyo is Negotiable Instrument Law and Batas Pambansa bilang 22. Okay, now we're expecting 2 questions for the October 2020 CPA board exam. Okay, bali ni-reduce yan. Okay, from 3, ginawa na lang siyang 2. Okay, now let us define first check. Okay, under section 185 of the Negotiable Instrument Law, a check is a bill of exchange drawn on a bank payable on demand. Except as herein otherwise provided, the provision of this act applicable to a bill of exchange payable on demand apply to a check. Okay, at take note, nag-a-apply ang BP22 sa all kinds of check. In fact, the law does not make any distinction as to what kind of check. Okay, now before we start, okay, do sa discussion ng BP22, let us distinguish first yung mala inse versus the mala prohibita. Okay, or sometimes malum inse and the malum prohibitum. Okay, pag sinabi nating mala inse, yung act or omission, naging punishable siya because they are considered as inherently wrong. Okay, they are evil in itself. Unlike yung mala prohibita, yung act or omission, naging punishable siya because the law simply prohibit it. Now, example, yung mga punishable under the revised penal code are mala inse. And those are punishable under special laws are mala prohibita. But take note that, okay, ang true test talaga natin is not whether or not punishable siya under the revised penal code or punishable siya under the special law. Ang talagang test natin is, yun bang act or omission ay naging punishable because they are evil in itself? If the answer is yes, then that is a mala inse. Pero kung yung act or omission naging punishable siya because the law simply prohibit it, then that is a mala prohibita. Okay, example ng mala inse. Okay, tingnan mo sa revised penal code. Okay, masama ang pumatay. Okay, that is evil in itself. Okay, kaya kapag nakapatay ka sa revised penal code, ang crime or felony na commit mo is homicide. Ngayon, kung may present siya na qualifying circumstances like treachery or alibosía, then pwede siyang mag-qualified into murder. Kung pinatay mo naman halimbawa yung okay, spouse mo, okay, o kaya okay, anak mo, tatay mo, nanay mo, then that is parricide. Okay, kung pumatay ka naman ng infant, okay, less than 3 years of age, then the case would be infanticide. Okay, alam natin ang pagpatay ay evil in itself. Kaya that is mala prohibita and that is punishable under the revised penal code. Okay, nagnakaw ka, theft. Okay, kung gumamit ka ng force or intimidation, okay, para makuha mo yung personal property, then that is okay, robbery. Kung gumamit ka naman ng fraud, okay, pwede siya mag-fall under estafa. Okay, hindi ba yung mga panloloko? Estafa, and that is evil in itself. Pero ano may example ng mala prohibita? Okay, example is illegal possession of firearms. Okay, masama bang may hawak na baril? Hindi, di ba? Pero the fact na meron kayong possession ng unlicensed firearms, you can be held criminally liable. Okay, because the law simply punish it. O kaya another is yung BP22 nga. Okay, itong bouncing check. Okay, kasi ang pinapunish sa BP22, okay, is the act of issuing, okay, insufficient fund. Okay, kaya ang pinapunish dito yung pag-issue mo ng check na worthless. Okay, at may knowledge ka at the time of issuance that it has no sufficient fund and it subsequently bounced, then covered yan ng BP22. Okay? Now, dito, okay, yung pag-issue mo lang ng bounce check, okay, is already punishable under the law. Now, okay, sabi dito, what the law punishes is the issuance of bouncing check. Okay? Ang pinapunish daw ng BP22, okay, yung pag-issue mo ng worthless check. Not the purpose for which it was issued, nor the terms and conditions relating to its issuance. The mere act of issuing a worthless check is a malum prohibitum. Kaya even an accommodation check are covered by BP22. Okay, bawa nag-accommodate ka lang, okay, or ginagaranti mo lang, okay, na yung principal obligation. Pero ikaw yung nag-issue ng check. Pero yung check na in-issue mo, subsequently present sa Drovy Bank at nag-bounce. At may knowledge ka at the time of issuance that it has no sufficient fund, then that is covered by BP22. Now, take note that BP22 took effect on June 29, 1979. Kaya ang covered lang ng BP22 are those check issued starting June 29, 1979 and onward. Hindi niya covered yung mga check na na-issued na prior to June 29, 1979, although it bounced only starting June 29, 1979 and onward. Okay, kasi otherwise, magre-result yan into an ex post facto law. Kaya halimbawa, okay, nag-issue kayo ng cheque, sabihin natin ng June 1, 1979. Pero, present siya sa Drovy Bank, okay, nung July 5, 1979. And nag-bounce. Okay, hindi yan covered ng okay, BP22. Okay, kasi yung check na na-issue na prior to the effectivity of the law. Okay, although yun nga, nag-bounce lang siya, okay, starting June 29, 1979 and onward. Hindi yan covered ng BP22. Kasi otherwise nga, magre-result yan sa ex post facto law. Pag sinabing ex post facto, you are making the act unlawful, wherein at the time of the commission, these are not yet punishable. Kaya ang rule is, hindi pwedeng mag-retroact ng criminal law. Now, okay, the government of the offense punished by BP22 is the act of making and issuing a worthless check or a check that is dishonored upon its presentation for payment. It's not the non-payment of all obligation which the law punishes. The law is not intended or designed to coerce a debtor to pay his debt. The thrust of the law is to prohibit under pain of penal sanctions the making of worthless checks and putting them in circulation because of its deleterious effects on the public interest. The practice is prescribed by the law. The law punishes the act, not an offense against property, but an offense against public order. Okay, now take note that in BP22, okay, ang pinapunish dito, yung pag-issue nga ng worthless check. Okay? Now, upon effectivity of the law, there are several petitioners questioning the legality of BP22. Kasi according to them, yung BP22 daw is unconstitutional because it violates the provision under the 1987 Constitution that no person shall be imprisoned for non-payment of debt or poll tax. Ang problema, ang BP22, meron siyang kulong. May imprisonment. Kaya ito ba ay constitutional? Okay, sabi ng Supreme Court, yes. Kasi ang pinapunish nga ng batas sa BP22 is not the non-payment of debt, but rather the issuance of a worthless check. Kaya kung ayaw mo makulong, wag kang mag-issue ng worthless check. Pero tama na walang nakukulong sa utang. Kasi ang pinapunish dito is not the non-payment of debt but rather the issuance of a worthless check. Okay, take note that this is not crimes against property. Okay, tulad ng estafa. But this is a crime against public order. Kasi every time daw na nag-i-issue kayo ng worthless check, nagdadagdag kayo ng boom check sa circulation. Nadadamage ang banking industry. Kasi just imagine kung ang lahat ng nagsisirculate na check ay worthless pala. Mawawala ng trust and confidence ang public na mag-accept ng check as a substitute for money. Remember, ang isang purpose ng check, di ba, ng negotiable instrument is substitute for money siya. Ang problema kung ang lahat nga naman ng check na nagsisirculate ay worthless. Mawawalan ng trust and confidence ang public na tumanggap ng cheque. Kaya pwedeng mag-interfere ang government through exercise ng police power to make it a criminal act. Para ma-prevent ang pag-circulate ng sobrang daming worthless check. Kasi otherwise, madadamage ang banking industry. Now, the enactment of BP 22 is a declaration daw by the legislature that as a matter of public policy, the making and issuance of worthless check is deemed public nuisance to be abated by imposition of penal sanctions. Although not legal tender, di naman talaga legal tender ang check. In fact, may right ang creditor to refuse a check because these are not legal tender. Pero sabi diyan, check have come to be perceived as a convenient substitute for currency in commercial and financial transactions. Now, the basis or foundation of such perception is confidence. If such confidence is shakes, the usefulness of check as currency substitute would be greatly diminished. Any practice, therefore, tending to destroy that confidence should be deterred, for the proliferation of worthless check can only create havoc in trade circles and the banking community. Okay, now, ano ba yung covered ng BP 22? Ano bang check covered dito? Sabi ng Supreme Court sa case ng Lozano versus Martinez, the language of BP 22 is broad enough to cover all kinds of check. Meaning, lahat daw ng check covered nito. Whether present dated, meaning dated check siya, post dated, or whether issues in payment of pre-existing obligation. Ibig sabihin, in-issue mo yung check na pre-existing obligation, or pwedeng given in mutual or simultaneous exchange for something of value. Kaya ibig sabihin, pag issue ka ng check, may kapalit ka agad. Or pwedeng in-issue ko yung check in payment of a pre-existing obligation, covered pa rin siya ng BP 22. In fact, even foreign check, as long as the check, are drawn in the Philippines, even though bounced abroad, are covered by BP 22. Ito lahat ito ay covered ng BP 22. Accommodation check. Tulad niyan, nag-issue ka ng check. Para i-accommodate ng kunwari yung borrower. Ang problema, yung check na in-issue mo, when it was presented to the drawing bank, it was dishonored for lack of sufficient fund. Then covered pa rin siya ng BP 22. Guaranteed check. Memorandum check. Di ba yung memorandum check, ito yung check na may nakalagay sa face ng check the word memorandum, memo or memo. Na ang understanding between the drawer and the payee is that the payee should not present the check to the drawing bank because the drawer is merely acknowledging his indebtedness to the payee. But if the payee present the check to the drawing bank and subsequently it bounced, that is covered by BP 22. Ganon din ang foreign check. As long as the check is drawn in the Philippines, although it bounced abroad, that is covered by BP 22. Pero by the way, yung cashier's check and manager's check are not covered, of BP 22. Now, sabi ng Supreme Court sa case ng Divilla versus Court of Appeal, foreign check, provided they are drawn and issued in the Philippines, though payable outside thereof, are covered by BP 22. Pero by the way, kung titinan mo, lumalabas, kailangan para ma-covered ng BP 22, dapat yung check either known in the Philippines, okay, although it bounced abroad. Now, in the case of People versus Bergiano, when a check was drawn before BP22 took effect on June 29, 1979, although it bounced after said date, the drawer is not liable. Kaya tandaan nyo, ang covered lang ng BP22, yung mga check na na-issued starting June 29, 1979 and onward. Hindi niya covered yung mga check na na-issued na prior to June 29, 1979, although it bounced only starting June 29, 1979 and onward. Kasi otherwise, magre-result yan sa ex post facto law. Kasi ang criminal law, prospective in application. Hindi siya pwedeng retroactive effect. Now, how BP22 is committed? Paano ba nakocommit ang BP22? Merong dalawang paraan. Ito yung first paragraph, ito yung second paragraph. Okay, sa first paragraph, sabi dyan, any person. Okay, manonotice nyo ha, ang pwedeng makakommit ng BP22, any person. Kaya pa, since ang ginamit ay word person, it can be a natural or juridical person. Ngayon, kung natural person, of course, yung signatory, okay, nung check. How about, okay, pagdating sa, okay, corporation, okay, which is a juridical person. In that case, okay, yung signatory din ng check, okay, na nagre-represent dun sa drawer. In fact, if you look the last paragraph of section 1, kaya sabi nga dyan, when a check is drawn by a corporation, company, or entity, okay, the person or persons who actually sign the check in behalf of such drawer shall be liable under this act. Kaya kung halimbawa ang signatory is the president, okay, o signatory niya yung treasurer, then both of them may be held criminally liable, okay, under BP 22. Okay, balikan natin na any person who makes. Kaya ang unang element ng BP22 is dapat nagkaroon ng making or drawing, okay, and issuance. Ano nga ibig sabihin ng issue? Kung titignan mo yun sa negotiable instrument laws, di ba sabi doon, issue means the first delivery of an instrument complete in its form as to constitute the transferee, a holder thereof. Kaya merong delivery for purpose of transferring title. Okay, tapos sabi dyan, to apply on account, okay, or for value. Okay, kaya ibig sabihin ang covered nitong BP22, i-apply mo dun sa pre-existing obligation or pwedeng simultaneous exchange with value. Tapos, third element, dapat may knowledge ka, knowing at the time of issue that he does not have sufficient fund in or credit. Pero syempre baka tanungin mo, sir, paano ipuprove ang knowledge? Ang knowledge is a state of mind. Okay, by the way, under BP22, may presumption kasi na kapag ang cheque ay tumalbog within 90 days from the date of check, it will create a prima facie presumption of knowledge that at the time of issuance, that it has no sufficient funds. Pero ang problema, okay, meron doon nakalagay na unless. Okay, unless sinettle mo siya or gumawa ka ng arrangement na babayaran mo in full within 5 banking days from the receipt of notice of dishonor in writing. Okay, dapat in writing. Okay, mamaya i-explain ko sa inyo. Okay, kaya yun, dapat i-prove na may knowledge at the time of issuance that it has no sufficient funds. And of course, the last element here is the subsequent dishonored by the drawee bank, okay, for lack of sufficient funds. Kaya nakalagay dyan, okay, which check is subsequently dishonored by the drawee bank for insufficiency of fund or credit would have been dishonored for the same reason had not the drawer without any valid reason ordered the bank to stop payments. Pero sabihin mo, sir, okay, ang nakalagay lang dyan, insufficiency of fund. Paano kung halimbawa, okay, dinishonor yung check kasi clinose yung account. Is that covered by BP22? Ang sinasabi lang, insufficiency of funds. Actually, meron isang case yan wherein sabi ng Supreme Court is okay, kasama even yung close account. Mas lalo na ngayon, di ba dapat? Okay? Now, kaya ibig sabihin, okay, ito, insufficient lang ang binanggit sa batas, but it covers actually, okay, those check that was dishonored by reason of closed account or totally unfunded account. Kaya ibig sabihin, doon sa paragraph 1, para makommit mo siya, okay, dito sa paragraph 1, at the time na nag-issue ka, may knowledge ka na, okay, at the time of issuance, that it has no sufficient fund. Pero sa paragraph number 2, para makommit mo naman ito, at the time of issuance, sufficiently funded siya. Pero hindi mo raw maintain yung account mo, okay, within 90 days from the date ng check. And subsequently, dishonored dyan ng Drovy Bank for lack of sufficient funds. Kaya tingnan natin yung number 2. Tingnan mo to ha. Any person. Siyempre, ang covered pa rin yan is natural sa juridical person having sufficient fund in or credit with the Drovy Bank when he makes or draws and issue a check. Kaya ang unang element natin, nagkaroon ka ng making or drawing and issuance of check. Pangalawa, okay, second element, at the time of issuance, sufficiently funded siya. Unlike yung paragraph 1, at the time of issuance, talagang wala siyang sufficient fund. At may knowledge ka, at the time of issuance, that it has no sufficient fund. Dito, meron siyang sufficient fund at the time of issuance, pero hindi mo raw maintain. Kaya nakalagay niyan, fail to keep sufficient fund or to maintain a credit to cover the full amount of check if presented within a period of 90 days from the date appearing thereon, for which reason it is dishonored by the Drovy Bank. Example lang. Okay, halimbawa sa paragraph 1. Okay, halimbawa ang fund ko lang sa bangko is 50,000. Nag-issue ako ng check, okay, amounting to 80. Okay, edi when the check was presented to the Drovy Bank, it was dishonored for lack of sufficient funds. Diba? Drawn again insufficient fund yan or no sufficient funds. Paragraph 1 yan. Kasi at the time of issuance, okay, no sufficient fund na. Pero dapat ma-prove na may knowledge ka nga at the time of issuance that it has no sufficient fund. Pero sa number 2, halimbawa, ang pera ko sa bangko is 50,000. Okay, nag-issue ako ng check worth 30,000 lang. E di at the time of issuance, sufficiently funded. Ang problema, after 3 days, winidraw ko kunwari yung 40,000. That's why when the check was presented to the Drovy Bank, it was dishonored for lack of sufficient fund. That is covered under second paragraph. Now, okay, punta tayo doon sa element, okay, no felony. Okay, ng offense. Okay, doon sa paragraph 1, bali ulitin ko, ang element ng offense natin, that a person makes or draw and issue any check. Kaya dapat making or drawing and issuance of check. Second, that the check is made or drawn and issued to apply on account. Okay, pwedeng existing obligation or simultaneous exchange yan with value. And number 3, that the person who makes or draws and issues the check knows, meaning knowledge, at the time of issue, that he does not have sufficient fund in or credit with the bank for the payment of such check in full upon its presentation. Kaya importante yan, dapat may knowledge. Pag-usapan natin later on, okay, yung knowledge dito. And number 4, that the check is subsequently dishonored by the Drovy Bank for insufficiency of fund or credit or had been dishonored for the same reason, had not the drawer, without any valid reason, ordered the bank to stop payment. Kaya covered nito kapag nag-stop order payment ka, okay, tapos, pero dapat i-indicate pa rin dun na, okay, ang reason because of the stop order payment is lack of sufficient fund. Okay, next, punta naman tayo sa element ng offense under paragraph, okay, 2. Okay, number 1, that a person had sufficient fund in or credit with the Drovy Bank when he makes or draws and issue a check. Kaya ibig sabihin dito sa second paragraph, at the time nag-issue ka, sufficiently funded siya. Pangalawa, that he fails to keep sufficient fund or maintain a credit to cover the full amount of the check if presented within a period of 90 days from the date appearing thereon. Okay? And number 3, that the check is dishonored by the drawee bank. Okay? Kaya yan yung tatlong element under second paragraph. Okay? Kaya nga sabi ko sa inyo, kung nag-issue ka ng check, is sufficiently funded, pero hindi mo naman maintain yung fund na yun within 90 days from the date ng check. In that case, pag yan ay subsequently dishonored for lack of sufficient fund, that is covered by second paragraph. Ngayon, okay, punta tayo doon sa comparison. Ano naman ang pinagkaiba ng BP22 okay doon sa estafa through issuance of a post-dated check? Kasi meron tayong estafa through issuance ng post-dated check under second paragraph of Article 315 of the Revised Penal Code. Okay, tingnan mo uli yung element. Okay, sa BP22, yan, di ba? Making, drawing, and issuance of any check on applied account for value, meaning ito, pwede mo i-separate yan. Okay? Ito yung first and second element. Third, okay, knowledge of the maker, drawer, or okay, issuer that at the time of issue, he does not have sufficient fund or credit with drawee bank for the payment of the check in full payment upon its presentation. And last is the subsequent dishonored okay, of check by the drawee bank for insufficiency of funds. Pero sa estafa, ang element niya that the offender post-dated or issued a check in payment on obligation contracted at the time the check was issued. Kaya mapapansin mo, hindi nito covered yung okay, issuance ng post-dated check ng pre-existing obligations. Kasi hindi kayo pwedeng magkaroon ng fraud. Okay? Kaya ang covered ng estafa dito is okay, simultaneous exchange dapat. Okay? Now, kaya hindi pwede yung may existing obligation ka, binayaran ko kunwari through issuance ng post-dated check, hindi yan covered ng estafa. Pangalawa, that such post-dating or issuing a check was done when the offender had no fund in the bank or his fund deposited therein were not sufficient to cover the amount of check. And last is deceit or damage to the payer thereof. Kasi di ba pag sinabi kasing estafa, ang unang papasok agad sa isip niyo is panloloko. Okay? Kasi estapador ka di ba? Pag estapador, ibig sabihin, nanloloko. May element of fraud. Kaya ibig sabihin, may element dito ng deceit or damage to the payer thereof. Unlike in BP22, wala siyang element of deceit. Okay, bigyan ka ng example. Okay, halimbawa, meron akong existing obligation sa iyo. Okay, ang ginawa ko, kulit ka kasi ng kulit eh. Singil ka ng singil. Siyempre, nainis na ako. Pero mo, pinautang na nga kita. Gusto mo pa, bayaran kita. Kaya sa inis ko, para manahimik ka sa kasisingil, inisyuhan kita ng post-dated check. Ang problema, when nag-arrive yung date at present mo yung check sa drawee bank, dishonored for lack of sufficient funds. Ang question, can you be held liable for BP22? The answer is yes. Kasi sa BP22, tumalbog yung check mo, may knowledge ka at the time of issuance that it has no sufficient fund covered ng BP22. At pwede yan, okay, na in-issue to apply on account, meaning existing obligation, or pwedeng simultaneous exchange. Pero pangalawang tanong, pwede bang estafa? The answer is no. Okay? Kasi pre-existing obligation yan eh. Kaya walang estafa under Article 315, second paragraph ng Revised Penal Code. Pero halimbawa, okay, bumili ako kunwari ng 100 sacks of rice. Okay, through issuance ng post-dated check. Pero nag-misrepresent ako na yan ay sufficiently funded. Kaya ni-release niya yung 100 sacks of rice. And subsequently, when it was presented to the drawee bank, nag-bounce. Question, can you be held liable for BP22? The answer is yes. Can you be held liable for estafa under Article 315, second paragraph ng Revised Penal Code? The answer is yes. Okay? Kasi dito, may element of fraud na. Pero another question, hindi ba to violation ng 1987 Constitution against right of the accused against double jeopardy? The answer is no. Because these are two distinct criminal offense. One is punished under BP22, okay, is the act of making, drawing, or issuing worthless check. And what is punished under estafa is the fraud that you commit. Okay? Yung panluloko. Okay, and BP 22 is a mala prohibita, while estafa under Article 315 second paragraph of the Revised Penal Code is a mala insect. Kaya since magkaiba, okay, these are two distinct criminal offense. There is no violation, okay, of double jeopardy, okay, under the 1987 Constitution. Now, by the way, ano ba ang penalty ng BP 22? Mababa lang naman. Makukulong ka lang naman. Okay, imprisonment of not less than 30 days but not more than 1 year. Or a fine of not less than but not more than double the amount. But in no case should exceed 200,000 pesos. Or pwedeng both at the discretion of the court. Kaya halimbawa, okay, ang check na inisyu mo is 50,000. Minimum fine is 50, then maximum is 100. Kung nag-issue ka ng cheque na 80,000 at tumalbog, pwede magkaroon ng fine na minimum of 80, maximum of 160. Pero kung nag-issue ka ng cheque 120 at ito ay nag-bounce, pwede kang minimum fine is 120, maximum is 200,000. Kasi hindi siya pwedeng lumagpas ng 200,000. Okay? Doon sa fine. Okay? Ngayon, or pwede nga may kulong na, may fine pa, at the discretion of the court. Pero by the way, meron kasing Supreme Court circular na ang sinasabi dito, between the penalty of imprisonment saka fine. Kung pwede raw i-impose ang fine, fine na lang. Huwag na mag-impose ng imprisonment, especially kung ikaw ay first-time offender. Pero take note, I want to clarify that this is just a rules on preference. Na kung pwedeng impose ang fine, fine na lang. Huwag na mag-impose ng imprisonment, especially nga kung ikaw ay isang first-time offender. In fact, sabi dito, in his decision in Eduardo Vaca versus Court of Appeal, the Supreme Court, Second Division per Mr. Justice B. Mendoza, modified the sentence imposed for violation of BP 22 by deleting the penalty of imprisonment and imposing only the penalty of fine in amount double the amount of the check. In justification thereof, the court said petitioner are first-time offenders. They are Filipino entrepreneurs who presumably contribute to the national economy. Apparently, they brought this appeal believing in all good faith, although mistakenly that they have not committed a violation of BP 22. Otherwise, they could simply have accepted the judgment of the trial court and applied for probation to evade prison term. It would best serve the end of criminal justice in fixing the penalty within the range of discretion allowed by Section 1, Paragraph 1, the same philosophy underlying the indeterminate sentence law. Observe, namely, that of redeeming valuable human material and preventing unnecessary deprivation of personal liberty and economic usefulness with due regard to protection of social order. In this case, we believe that a fine in an amount equal to double the amount of check involved is an appropriate penalty imposed on each of the petitioners. Pero ang problema, okay, nung na-issue yung circular na to, yung iba kasi na-confuse. Ibig bang sabihin, wala ng penalty of imprisonment? That's why, okay, ang Supreme Court nag-issue ng another circular. Okay? Sabi dito naman sa circular, Supreme Court Circular number 13-2001. It does not mean that the court can no longer impose a penalty of imprisonment. Okay, ang sinasabi lang ng Supreme Court Circular number 12-2000, kung pwedeng i-impose ang penalty of fine, mag-impose na lang ng fine. Huwag na mag-impose ng penalty of imprisonment. Kumbaga, rules on preference lang. Okay, pero it does not mean that the court can no longer impose a penalty of imprisonment. Okay, kasi kung halimbawa sa tingin ng judge, okay, na mas appropriate ang penalty of imprisonment, okay, it means yung Administrative Circular number 12-2000 daw is not a hindrance to impose a penalty of imprisonment. Kaya kasi sinasabi dito, the clear tenor and intention of Administrative Circular number 12-2000 is not to remove imprisonment as an alternative penalty, but to lay down a rule of preference lang in the application of the penalties provided for in BP 22. Kasi otherwise, if the court will remove penalty of imprisonment, that is judicial legislation. That is within the power of Congress dapat. That is not within the power of the judiciary. Kaya, ibig sabihin, rules on preference lang. Okay, sabi dyan, the pursuit of this purpose clearly does not foreclose the possibility of imprisonment for violation of BP 22. Neither does it defeat the legitimate intent behind the law. Thus, Adversive Circular Number 12-2000 established a rule of preference in the application of the penal provision of BP 22, such that when the circumstances of both the offense and the offender clearly indicate good faith or clear mistake of facts lang. Yung ibig sabihin, kung merong good faith sa part ng thrower, or that is a clear mistake of facts lang, mas better na mag-impose ng fine lang, not imprisonment. Pero sabi dito, needless to say, the determination daw, okay, of whether the circumstances warrant the imposition of a fine alone rests solely upon the judge. Should the judge decide that imprisonment is more appropriate penalty, Administrative Circular Number 12-2000 ought not be deemed a hindrance. Kasi nga kung sa tingin ng judge, for instance, na ito is tainted with negligence or total disregard of the law, then kasi kung sa tingin ni judge, talagang hindi ito clear mistake of facts lang. Okay, or no good faith on the part of the drawer. Then, then the judge can still impose a penalty of imprisonment. Kasi nga rules on preference lang siya. Ngayon, Administrative Circular Number 12-2000 does not remove imprisonment as alternative penalty for violation of BP 22. The judge concerned may, in the exercise of sound discretion, and taking into consideration the peculiar circumstances of each case, determine whether the imposition of fine alone would best serve the interest of justice, or whether, forbearing to impose imprisonment would depreciate the seriousness of offense, work, violation on the social order, or otherwise be contrary to the imperative of justice. Kasi halimbawa nga naman, hindi ka na first-time offender. Bawa, na-convict ka na before for BP 22, nag-impose ng penalty of fine lang. Later on, nag-issue ka na naman ng cheque, tumalbog na naman. Now, in that case, since hindi ka na first-time offender, then the court can now impose a penalty of imprisonment. Okay, sabi dyan, should only a fine be imposed? Kasi di ba pwedeng halimbawa, nag-decide for instance yung judge na mag-impose ng penalty of fine lang. In that case, pwedeng mag-apply yung tinatawag na subsidiary imprisonment dito. Subsidiary penalty under the revised penal code. Ano ba yung sinatawag na subsidiary penalty? Kung hindi mo kayang magbayad ng fine, di kulong ka pa rin. Okay? Kaya kung babasahin mo to, ito meron ng amendment sa Article 39 ng Revised Penal Code, that is Republic Act 10159. Okay, dated April 10, 2012. Okay, nag-took effect yan 15 days after publication official gazette. Okay, to publication in official gazette after 15 days. Ngayon, kung titingnan mo dito sa article section 1 ng RA 10159 amending section 39 of the Revised Penal Code. Okay? Yung nakalagay doon sa Act number 3815, nakalagay dyan, when the principal penalty imposed be only a fine. Nag-impose ng fine lang talaga. Okay, dapat wala kang kulong kasi fine lang. Pero ang problema, hindi siya nakapagbayad ng fine. Sabi dyan, the subsidiary imprisonment shall not exceed 6 months daw if the culprit shall have prosecuted for grave or less felony and shall not exceed 15 days if for a light felony. Kaya kung hindi ka makapagbayad kunwari ng fine, tapos yung amount dito is 40,000, okay, below, then makulong ka pa din. Okay? Pasok yan dito. Okay? Yan yung tinatawag na subsidiary penalty. Okay? Pero kung may pera, nabayaran yung fine, of course, wala siyang kulong. Okay, by the way, importante itong prescriptive period. Okay? Napaka-importante ng prescriptive period sa mga criminal case. Kasi once the criminal act is already prescribed, okay, hindi na siya pwedeng i-file. Kasi kahit filean ka ng criminal case, then you can file a motion to quash the information on the ground of prescription. But the problem is that if you look the provision under BP22, walang provision regarding prescriptive period. Kaya pwede natin i-apply yung Act number 3326. Ito yung lumalabas na prescriptive period for special laws. Okay, yung Act number 3326, sabi doon, an act to establish period of prescription for violation penalized by special act, and municipal ordinance, and to provide when prescription shall begin to run. Now, since ang range ng penalty of imprisonment ng BP22 is not less than 30 days but not more than 1 year, nandun siya sa range ng dito, imprisonment of more than 1 month but less than 2 years. Kaya basically nasa range siya nito. Kaya lumalabas ang prescriptive period natin for violation of BP22 is 4 years. Okay? Kaya once na tumalbog na yung cheque, lumagpas na yung 4 years, hindi ka na pwedeng kasuhan pa for violation of BP22 because the action is already prescribed. Now, punta tayo sa evidence of knowledge and sufficient funds. Sabi ko sa inyo, napaka-importante nito. Kasi maraming cases ang nadidismiss kasi hindi na po-prove ng prosecution na yung drawer ay may knowledge at the time of issuance that it has no sufficient funds. At ang sabi ko kanina, may presumption sa batas na kapag ang cheque ay tumalbog within 90 days from the date ng cheque, mag-create siya ng prima facie presumption of knowledge that at the time of issuance, it has no sufficient funds. Pero ang problema, may nakalagay kasi dyan na unless such maker or drawer pays the holder thereof the amount due thereon. Kaya kung babayaran mo kunwari yan, binayaran mo yung cheque, gumawa ka ng arrangement na isettle or bayaran yan in full within 5 banking days, na-rebut kagad ang presumption. Kaya may hirapan ng prosecution na i-prove. That is actually a defense, a complete defense. Na kapag na-settle mo yan within 5 banking days upon receipt ng notice. By the way, class, ang nakalagay dyan after receiving notice, ano to? Notice of dishonor oral or notice of dishonor in writing. Now, under the negotiable instrument law, ang notice of dishonor pwedeng oral o pwedeng in writing. Pero for purpose of charging a person for violation of BP22, insufficient ang notice of dishonor na oral. Kasi it must be a notice of dishonor in writing. That is the pronouncement of the Supreme Court in the case of Dumangsang. Kaya lumalabas, pag wala ka natanggap na notice of dishonor in writing, hindi ka makukonvict for violation of BP22. Kasi yan yung reckoning period ng 5 banking days. Kumbaga, binibigyan ka ng chance ng batas na i-rebut yung presumption. Kaya pag nakatanggap ka na ng notice of dishonor in writing, dapat bayaran mo yan or gumawa ka ng arrangement na isettle yan in full within 5 banking days upon receipt ng notice of dishonor in writing. Otherwise, mag-a-arise ang presumption. Ang presumption is that alam mo at the time of issuance that it has no sufficient fund. Na-prove yung element na may knowledge. Kasi yun yung crucial dyan. I-prove na may knowledge ka at the time of issuance that it has no sufficient funds. Kaya dapat kapag halimbawa natalbogan ng cheque, bigyan mo kaagad ng notice of dishonor in writing. Ngayon, pag natanggap niya, na-prove mong natanggap niya, dapat within 5 banking days, isettle niya. Bayaran niya o kaya magkaroon ng arrangement na ibabayaran niyan in full within 5 banking days. Otherwise, na-prove na may knowledge na at the time of issuance that it has no sufficient funds. Kaya, ang problema is dapat i-prove na may knowledge. Diba? Dapat na-prove na na-receive niya yung notice of dishonor in writing. Yan yung laging cases Kasi halimbawa, ako, dininay ko. Nag-issue ka ng cheque, tumalbog. Dininay ko naman na wala ko natanggap na notice of dishonor in writing. Di ang burden of proof nasa part ng prosecution to prove na natanggap ko yung notice of dishonor in writing. Kasi kung hindi nila approve, hindi na approve na may knowledge ako at the time of issuance that is sufficient fund. Kasi binibigyan nga ako ng batas ng 5 banking days upon receipt ng notice of dishonor in writing para i-settle to, okay, or magkaroon ng arrangement na i-settle it. Okay, kasi pag binayaran ko yan or na-settle ko siya, within 5 banking days, na-rebut ko yung presumption. Sabi dyan, evidence of knowledge of sufficient fund. For this presumption to arise, the prosecution must prove the following. Letter A, the check is presented within 90 days from the date of the check. Yan ang ipoprove ng prosecution para ma-prove na may knowledge ka. Present yan within 90 days from the date ng check. Pangalawa, the drawer or maker of check received notice. Dapat na-prove na nakatanggap yung drawer ng notice of dishonor in writing. Okay, that such check has not been paid by the drawee. And the drawer or maker of a check fails to pay the holder or the check the amount due thereon or make arrangement for payment in full within 5 banking days after receiving notice that such check has not been paid by the drawee. Yan yung dapat i-prove ng prosecution para ma-prove na may knowledge ka at the time of issuance that it has no sufficient funds. Okay, ngayon, ito yung sinasabi ko sa inyo, yung case ni Dumagsang versus Court of Appeal. Na ang sinasabi ng Supreme Court dito, yung notice dapat hindi oral. It must be a notice of dishonor in writing. Kasi kung ang binigay sa iyo ay notice of dishonor lang na oral, ay hindi yan sufficient for conviction. Kasi nga, yung reckoning period ng 5 banking days is okay upon receipt ng notice of dishonor in writing. In fact, sabi ng Supreme Court dito, while indeed, Section 2 of BP 22 does not state that the notice of dishonor be in writing, taken in conjunction, however, with Section 3 of the law, okay, that when there are no sufficient funds in or credit with such drawee bank, such fact shall always be explicitly stated in the notice of dishonor or refusal. A mere oral notice or demand to pay would appear to be insufficient for conviction under the law. Okay, the court is convinced that both the spirit and letter of the bouncing check law would require for the act to be punished thereunder not only that the accused issued the check that is dishonored, but that likewise the accused has actually been notified in writing of the fact of dishonor. The consistent rule is that penal statutes have to be construed strictly against the state and liberally in favor of the accused. Okay? Kaya tandaan nyo ha, dapat notice of dishonor in writing. Pag natanggap mo na yan, binibigyan ka ng batas ng 5 banking days para gumawa ng arrangement or isettle to. Otherwise, mag-a-arise yung presumption na may knowledge ka at the time of issuance that it has no sufficient funds. Ngayon, proof of receipt of notice of dishonor, ito yung sinasabi ko sa inyong crucial. Kaya dapat ma-prove dito ng prosecution na natanggap ng drawer yung notice of dishonor in writing. Especially kung yan ay dinenay ng drawer. Kasi ang burden of proof ay mag-ship sa prosecutor. Okay, the prosecutor must prove na na-receive mo ang notice of dishonor in writing. Otherwise, okay, the case should be dismissed. Kaya sabi ng Supreme Court naman sa case ng Caras versus Court of Appeal, the absence of proof that petitioner received any notice informing her of the fact that her check were dishonored and giving her 5 banking days within which to make arrangement for payment of the said check prevent the application of disputable presumption that she had knowledge of the insufficiency of her fund at the time she issued the check. Kasi di ba, sabi ko sa inyo, pag yung check tumalbog within 90 days yan, may presumption ka agad na may knowledge ka. Mapuprove yung isang element. Mapuprove yung element na may knowledge ka at the time of issuance that it is not sufficient fund. Ang problema, walang presumption kung sinettle mo yan within 5 banking days. Kaya sabi yan, absent such presumption, the burden shift to the prosecution to prove that petitioner had knowledge of the insufficiency of her fund when she issued the check. Said check, otherwise she cannot be held liable under the law. Ngayon, sabi dyan, registry return card must be authenticated to serve as proof of receipt of letter sent through registered mail. Thus we held, it must appear that the same was served on the addressee or duly authorized agent of the addressee. In fact, the registry return receipt itself provide that registered article must not be delivered to anyone but the addressee or upon addressee written order, in which case the authorized agent must write the addressee name on the proper space and then affix legibly his own signature below it. Okay, the presentation of the registry card with an authenticated signature. Kasi dapat i-authenticate yung signature dito na ito talaga yung signature ng drawer na na-receive niya yung notice of dishonor in writing. Okay, kasi otherwise, wala ngang presumption na may knowledge ka at the time of issuance that it has no sufficient fund. Kaya sabi dyan, pag present, okay, an authenticated signature does not meet the required proof beyond reasonable doubt that petitioner received such notice, especially considering that he denied receiving it. As there is insufficient proof that petitioner received notice of dishonor, the presumption that he had knowledge of the insufficiency of fund cannot arise. Absent yung isang element ng BP20. Ngayon ito, duty ng drawee, okay, rules on evidence. Sabi yan, it shall be the duty of the drawee of any check when refusing to pay the same to the holder thereof. Kaya ibig sabihin, kung yung bangko, dinishonor yung check, tatatakan mo siya. Ilalagay mo in plain language, written, printed, or stamped in plain language daw thereon, or attach thereto the reason for drawee's dishonor or refusal to pay the same. Provided that when there is no sufficient fund in or credit with such drawee bank, sabi dyan, such fact shall always be explicitly stated in the notice of dishonor or refusal. Okay? Kaya normally tinatakan ng bangko yan, NSF or no sufficient fund. In all prosecutions daw under this act, the introduction in evidence of any unpaid and dishonor check having the drawee refusal to pay is stamped or written thereon or attached thereto, with the reason therefore as aforesaid shall be prima facie evidence of making or issuance of said check, and the due presentment of the drawee for payment and the dishonor thereof, and that the same was properly dishonored for reason written, stamped, or attached by drawee on such dishonored check. Kasi once tinatakan ng bangkong NSF or no sufficient fund or drawn against sufficient fund dyan, na-prove mo yung last element ng BP22. Yan yung subsequent dishonored by the drawee bank for lack of sufficient fund. Okay, now the introduction in evidence of any unpaid and dishonored check with the drawee's refusal to pay stamp or written thereon or attached thereto shall be prima facie evidence of the making or issuance of the check. Kaya ibig sabihin, kung tinatakan na ng drawee bank yan na drawn against sufficient fund, yan, approved. Making or issuance of check, the due presentment of the drawee for payment and the dishonor thereof. Okay, the fact that the same was properly dishonored for the reason written, stamped, or attached by the drawee on such dishonored check. Okay, ngayon meron tayong i-discuss na isang case. Ito medyo kakaiba kasi, kaya discuss ko tong case ng CSIP versus Court of Appeal. Okay, ngayon itong si Francisco T. CSIP, bumili ito ng townhouse from Francer Realty Corporation. Ito yung developer ng townhouse. Now, as a condition for the sale, the buyer was required to issue 48 checks amounting to 9,304 each. But the problem is that etong si seller, itong developer, okay, ayaw nang ituloy yung pag-construct ng townhouse. Baga nagkaroon ng breach. Ayaw nang ituloy yung pag-construct ng townhouse. Siyempre ito naman si buyer, since na-issue na niya yung cheque na mga post-dated, okay, pag nag-arrive yung date ng check, bawa, okay, yung unang month, 'di ba? Nag-arrive na yung arrive na yung date ng check. Ang ginagawa ng buyer, mag-stop order payment siya. Okay? Yung next month naman, pag mag-arrive na uli yung date, stop order payment. Kaya ibig sabihin, every time na darating yung date ng check, mag-stop order payment yung buyer. Ang problema, every time na yung drawer ay nag-stop order payment, meron niyang hefty bank charges. Kaya ang ginawa doon class ng employee doon sa Citibank, ito yung drawee bank, in-advise niya yung drawer, itong si Francisco T. CSIP, na bakit hindi na lang niya i-close yung account para ma-avoid yung hefty bank charges. Ito naman si Francisco T. CSIP, okay, para maiwasan nga yung hefty bank charges, sinunod niya yung advice ng employee ng Citibank. Kaya clean house account. Ang problema, yung mga subsequent check na nag-arrive na yung date, pag present sa Drawee Bank, it was now dishonored. Okay, dati kasi ang unang dinidishonored kasi, di ba, stop order payment. Pero may sufficient fund. Pero ito, dinishonor na, okay, because close account. That's why, later on, si Francel Realty Corporation, nag-file na to ng case against Francisco T.C. Sip for violation of BP22. In fact, Francisco T.C. Sip was convicted sa lower court. Kaya umakyat siya hanggang umabot ng Supreme Court. Ang naging issue lang is whether or not, okay, liable ba si Francisco T.C. Sip for violation of BP22? Sabi ng Supreme Court dito, to begin with, the second element involves knowledge on the part of the issuer at the time of check issuance that he did not have enough fund or credit in the bank for payment thereof. Upon is presented. BP22 creates a presumption juris tantum that the second element prima facie exists when the first and third element of the offense are present. But such evidence may be rebutted. If not rebutted or contradicted, it will suffice to sustain a judgment in favor of the issue which it supports. As the evidence for the defense showed, the closure of petitioner account number 845515 with Citibank was not for insufficiency of funds. It was made upon the advice of the Drawee Bank to avoid payment of the hefty bank charges each time petitioner issued a stop payment order to prevent the encashment of post-dated checks in private respondent possession. Said evidence contradict the prima facie presumption of knowledge of insufficiency of funds. Okay, sabi ba ng Supreme Court? While BP22 was enacted to safeguard the interests of the banking system, kasi di ba kaya in-enact yung BP22 para ma-avoid yung pag-circulate ng boom check, okay, para ma-avoid yung pagdami ng nagsisirculate ng boom check sa circulation. Kasi nga nadadamage yung banking industry. So sabi ng Supreme Court, it is difficult to see how conviction of the accused in this case will protect the sanctity of the financial system. Moreover, under PD number 957 kasi doon sa Townhouse Act, may nakalagay dyan na provision na may right ang buyer, yung townhouse owner, na mag-suspend ng payment kapag hindi kinontinue ng developer, okay, yung develop ng property. Okay? Kaya sabi ng Supreme Court dito, yun nga, moreover, protection must also be afforded in the interest of townhouse buyer under PD number 957. A statute must be construed in relation to other laws so as to carry out the legitimate end and purpose intended by the legislature. Court will not strictly follow the letter of one statute when it leads away from the true intent of legislature and when ends are inconsistent with the general purpose of the act. More so, when it will mean the contravention of another valid statute, both laws have to be reconciled and given due effect. Note that we have upheld the buyer's reliance on Section 23 of PD number 957 to suspend payments until such time as the owner or developer had fulfilled its obligation to the buyer. This exercise of its statutory right to suspend installment payment is, to our mind, a valid defense against the purported violation of BP22 that petitioner is charged with. That's why he was acquitted. Okay, dito parang lumabas, hindi na tiningnan yung literal na word ng batas. They go into the spirit for the enactment of BP22. Kasi just imagine nga naman, di ba? Ang unang nag-breach dito yung developer. Porque hawak na niya yung cheque, di ba? Kakasuhan ka ngayon ng BP22. Okay? Yung nung present yung check sa Drawee Bank for lack of sufficient funds. Parang magke-create naman to ng injustice. Diba? Kaya parang lumalabas itong CSIP, medyo kakaiba yung case niya. Yeah, diniscuss. Okay. Let us proceed now sa multiple choice problem. Okay? Multiple choice number 1. The crime of BP22 is, okay, sabi natin ng BP22, ang pinapunish is the act of making, drawing, or issuing worthless check. And this is a malum prohibitum or mala prohibita. Kasi pinapunish dito, okay, yung act of making, drawing, or issuing purchase check, regardless of your intention. Kaya ang sagot is B. Multiple choice number 2. The following are the elements of BP22 except, okay, letter A, the making, drawing, and issuance of any check to apply for account or for value. Check. Second, the knowledge of the maker, drawer, issuer that at the time of issue, he does not have sufficient fund in or credit with the drawing bank for the payment of the check in full upon its presentment. Check. Letter C, deceit or damage to the pay thereof. No. Kasi ang deceit or damage hindi element ng BP22 but rather element siya ng estafa under Article 315 second paragraph of the Revised Penal Code through issuance of a post-dated check. Kaya ang sagot dyan is cut. Yung letter D naman, the subsequent dishonor of the check by the drawing bank for insufficiency of fund or credit or dishonor for the same reason had not the drawer without any valid cause ordered the bank to stop payment, that is element of BP22. Letter C. For number 3, the penalty for violation of BP22 is, okay, di ba ang penalty natin dyan is imprisonment of not less than 30 days but not more than 1 year, or a fine of not less than but not more than double the amount but in no case should exceed 200,000 pesos or pwedeng both at the discretion of the court. Okay, hanapin natin dito sa ABCD. Okay, wait lang ha. Okay, ang sagot natin sa number 3 is letter A. Imprisonment of not less than 30 days but not more than 1 year, or a fine of not less than but not more than double the amount of the check, which fine shall in no case exceed 200,000 pesos, or pwedeng both, okay, such fine imprisonment at the discretion of the court. Okay, syempre ito mali, 2. Mali rin itong 2. 1 month lang yun eh. Ang nagpamali naman dito, 60 days. Dapat 30 days lang. Okay, number 3 is letter A. For number 4, under BP22, if the amount of the check involved is 80,000, the maximum fine that may be imposed is, okay, di ba ang fine natin is not less than but not more than double the amount but in no case should exceed 200,000. Kaya 80, maximum double nito, 160. Pero pag lumagpas ng 200, maximum 200. Kaya ang sagot natin dito is letter B, 160. Okay? Number 5, there is a prima facie evidence of knowledge of insufficiency of fund when the check is refused within a period of 90 days from the date of check. Okay, ang sagot is 90 days from the date of check, letter B. Okay, for number 6, under section 2 of the bouncing check law, the making, drawing, and issuance of check payment of which is refused by the drawee because of insufficient fund in or credit with such bank when presented within 90 days from the date of the check shall be prima facie evidence of knowledge of such insufficiency of fund or credit unless such maker or drawer pays the holder thereof the amount due thereon or makes arrangement for payment in full by the drawee of such check within 5 banking days after receiving notice that such check has not been paid by the drawee. The notice required under section 2 of the bouncing check law, okay, kailangan notice of dishonor in writing. Okay, not necessarily public instrument. Basta writing lang. Okay, pwedeng private, pwedeng public instrument. Kaya ang sagot natin letter is letter A. Okay? Sabi ng Supreme Court sa Dumangsang versus Court of Appeal, insufficient ang oral notice. Okay, number 7, the prescriptive period for violation of bouncing check law is 4 years, di ba? Okay, based dun sa provision under the law. Sa prescriptive period for violation of special laws and municipal ordinance. Kaya lumalabas 4 years ang prescriptive, letter C. Okay? The end na. Okay, bali, ang i-discuss kung next topic natin is the law on partnership. Okay, law on partnership tayo. Okay, thank you.